In the Court of Appeals, 8th Judicial District, Cuyahoga County, Ohio. Carrington Mortgage Services, LLC. Plaintiff Appellee. B.S. Princess Ada Israel. Defendant Appellant. Appeal No. CA 25-115296. Trial No. CV 24-999054. On appeal from the Cuyahoga County Court of Common Pleas. Reply of Defendant Appellant Princess Ada Israel. Tamara E. Gurchik, 009-0798, Princess Ada Israel. 4805 Montgomery Road 4364, Western Center Boulevard. Suite 320 Suite 5077. Norwood, Ohio 45212 Fort Worth, Texas 76137. 513-396-8100303, 552-3777. tgurchik@logs.com 2591leroad@gmail.com. Attorney for Pro SE. Carrington Mortgage Services LLC. 1600 South Douglas Road Suite 200A. Anaheim, California 92806. Table of Contents. Table of Authorities, 2. Corrections on Appellant's Brief, 3. Cross Appellee's Brief Statement of Case, 3-6. Cross Appellee's Brief Statement of Facts, 6-7. Cross Appellee's Brief Affirmative Defenses, 8. Cross Appellee's Brief Jurisdiction, 8. Cross Appellee's Brief Websites, 8-9. Cross Appellee's Brief Assignment of Errors, 9. Reply, 9-11. Conclusion, 11-13. Prayer for Relief, 14. Certificate of Service, 15. Appendix, 16. Websites, 16. Table of Authorities. 18 United States Code 1014, 9. Ohio Revised Code 5301.07, 9. Ohio Revised Code 5301.07, 2, B, 1, 10,13. Ohio Rules and Procedures Rule 4.3b, 1, 2, 3. Come now, Defendant Appellant Princess Ada Israel, Ms. Israel, bring before the Court of Appeals for review, for the corrections on Defendant Appellant's brief, for the arguments against, Plaintiff Appellee Carrington Mortgage Service, LLC, CMS, brief submitted by Legal Counsel Tamara E. Gurchik, Attorney Gurchik, in addition a reply and prayer for relief based on the entire case CV 24-999054 filed in Cuyahoga County Common Pleas Court on June 17, 2024. 2. Correction on Defendant Appellant's brief. Page 4 Correction removed websites from Table of Authorities to Appendix. Page 28 Line 6 Matthew Midland Correction, 008290, 2, 008-8290. Page 28 Line 6 Brian Tekulve, 102,063, Attorney Tekulve, added, Attorney Tekulve was omitted in error, he was on the initial complaint and removed on the publication for unknown reasons. Page 29 Spelling error Gurich to Gurchik. 3 Cross Appellee's Brief Statement of Case. On June 17, 2024 Ms. Israel's last known address was Livingston, Texas. The loan servicer was aware of her last known address as there is proof of a correspondence sent to the Livingston, Texas address on February 14, 2024. Attorney Gurchik failed to notify an out-of-state pro se litigant, in accordance to Rule 4.3b, 1, 2, Service to Last Known Address. CMS monitors the property monthly, was aware the property was vacant on February 21, 2024. 5 attorneys representing CMS sent a process server and certified letter to a vacant property and no notice whatsoever to the Livingston, Texas address on file. Ms. Israel was notified via text message from a stranger. Afterwards she notified the trial court of her Fort Worth, Texas address. The Livingston, Texas address was Ms. Israel's valid address with CMS. If it was out of abundance of caution to file a publication on August 19, 2024, due to uncertainties of delivery, then why, pray tell, after Ms. Israel filed her answer on August 22, 2024, Magistrate Judge Amy R. Jackson entered on the docket on October 28, 2024, plaintiff is ordered to file all necessary dispositive motions and all necessary title work/affidavits within 30 days of this order, or this case could be dismissed without prejudice. Notice issued, and on October 8, 2024, Attorney Gurchik filed a motion for default judgment. The actions prove the publication was not out of abundance of caution, rather to set in motion a default judgment hearing. The trial court showed bias with the October 28, 2024 docket entry against Ms. Israel, who answered the complaint, raised mortgage fraud issues, title defect, and scheduled an in-person default judgment hearing for an out-of-state, pro-se litigant 1,200 miles away. The trial court failed to answer Ms. Israel's motion for a conference call in a timely manner, and called during the default judgment hearing left a message with no return phone number, in so deprived Ms. Israel of due process and her right to be heard. UWM and CMS plan was to force a deed in lieu or make Ms. Israel homeless to extract pain, punishment, and cause extreme trauma to a disabled war veteran for not selling the property to investors. The loan servicers, by their collective actions of manufactured delays, were indirectly setting up a murder, out of the state of Ohio, so that no one in Ohio would be blamed, or trying to provoke her to commit suicide, ultimately to eliminate Ms. Israel so they could file the foreclosure, obtain the default judgment, sell the property and clear the sellers from mortgage fraud claims, and later file a claim with the VA for approximately $60,000. Ms. Israel would not be around to dispute the claim. Coincidentally, after the default judgment decision, around March 2025, Ms. Israel's daughter was murdered in Texas. Days later, the sellers whom she had contracted with to purchase 10 acres of land filed a bogus foreclosure on her 10 acres of land in Texas. In hindsight, it was decided on June 17, 2024 or earlier that the foreclosure would end in a default judgment, by the actions of the 5 attorneys and trial court. By their collective actions, Ms. Israel was not notified at the Livingston, Texas address. The publication was filed not out of abundance of caution, rather to set a default judgment in motion. She was excluded from the default judgment hearing, and there was no recording of the default judgment hearing. Coincidentally, Ms. Israel's Ohio files were hacked on June 13, 2024. Death threats if she answered or filed any complaints, several attempts on her life during that time. She was unable to rent an apartment due to the 120-day lates posted on her credit reports from November 30, 2023 through May 31, 2024, along with threats to her family not to allow Ms. Israel to stay with them. Therefore, CMS intentionally made Ms. Israel homeless, so that she had no record of residence. In fact, she remains homeless since February 21, 2024 due to CMS posting 120-day lates from November 30, 2023, after CMS was notified on November 17, 2023, about the upcoming VA forbearance. They posted a 120-day late on her credit reports. Mind you, CMS posted nothing on Ms. Israel's credit reports between August 2023 through November 29, 2023. It does not take 100 days to post an account with the credit bureaus. Afterwards, CMS placed Ms. Israel's loan in a VA forbearance that was allocated for veterans who wanted to keep their homes from December 1, 2023 through May 31, 2024. Posted 120-day lates on her credit reports against the terms of the VA forbearance protocol. The trial court ruled with evidence discussed at the default judgment hearing failed to notify Ms. Israel by email on December 18, 2024. The clerk of court mailed her a copy of Magistrate Amy R. Jackson's decision from Cleveland, Ohio to Fort Worth, Texas on December 27, 2024. Ignored motions, waited for no apparent reason, until July 03, 2025 to order the sale of the property. Again, no email notification to Ms. Israel, and abruptly changed the case from active to inactive. Appellee's statement of facts. Between January 08, 2020 through February 21, 2024, Ms. Israel was and currently a victim of mortgage fraud, failure to disclose pertinent documents, inflated appraisal, excessive repairs, were concealed, harassed daily, and received numerous death threats while surviving in a dilapidated property. Ms. Israel mentioned she was under duress and the trial court did nothing. UWM coerced Ms. Israel to take a 1-year forbearance from October 1, 2021 through October 1, 2022, even though she only needed to be 6 months in the rears to commence foreclosure proceedings. Afterwards, she denied 2 loan modifications, even though she only needed 1. Around March 21, 2023, the VA requested from UWM and approved Ms. Israel to foreclose on 2591 Lee Road, Cleveland Heights 44118. UWM agreed to expedite Ms. Israel's foreclosure, after she completed an additional 90 days for no apparent reason, all to delay the foreclosure. UWM sent a default demand letter via their attorney, demanded payment by August 1, 2023. Ms. Israel responded, to proceed with foreclosure, around June 2023. UWM notified Ms. Israel July 2023 the loan would transfer to CMS around August 1, 2023. Ms. Israel contacted CMS in the month of July 2023, who claimed they would resume the foreclosure upon the completion of the transfer of loan documents. Per CMS's legal counsel, the documents were transferred after July 24, 2023. Upon receipt and review of Ms. Israel's loan documents, CMS should have referred the loan to the authorities for alleged mortgage fraud or filed the foreclosure from the approval of the VA and UWM emails in the month of March 2023. November 17, 2023, the VA notified loan servicers to hold foreclosures for veterans who wanted to keep their homes. November 30, 2023, the VA moratorium purpose was to help veterans keep their homes and no negative credit reporting. CMS posted 120-day late starting November 30, 2023 through May 2024 on Ms. Israel's credit reports and informed her there was a freeze on VA foreclosures until May 31, 2024. CMS used this moratorium to delay the foreclosure filing, to run the statute of limitations down that cures minor defects to title for the missing acknowledgement form and city approval. The loan servicers knew Ms. Israel was under duress with every phone call to the loan servicers, and her websites published her duress. Both loan servicers knew Ms. Israel's loan met all the criteria for an alleged house flipping mortgage fraud case and allegedly engaged in deceptive business practices, violation of RESPA VA, and conspired with the sellers to dump a $250,000 foreclosure on Ms. Israel. Appellee's brief affirmative defenses. Ms. Israel's answer to complaint, page 1, line numbers 2, 3, 14, 23, 24, all include affirmative defenses of improper transfer of title, and line number 17 requested dismissal due to mortgage fraud. 6. Appellee's brief jurisdiction. Ms. Israel brings her prior submitted brief with 8 assignments of errors and her reply before this court for considerations with notice that is on page 5, line number 8. Ms. Israel stated, as with other appellate brief, statements of issues for review. However, the brief for appellant case #CA25-115,174 filed by attorney Rachel, there is no mention in her brief for jurisdiction and final appealable orders, nor does attorney Gurchik dismiss the error of assignments for lack of jurisdiction pursuant to final appealable orders. Therefore, Ms. Israel requests that assignments of errors 1 through 8 are reviewed, as it is not mandatory, in filing to include jurisdiction/final appealable orders. 7. Appellee's brief websites. The websites were included in trial court are her evidence that was published over the years shows the title defect, parties involved in the transfer who concealed and or forged information, abuse, duress, hate crimes, crimes against a disabled person, interference with her phones, computers, website publishing, aggressive investors and intentional delays that ran the statute of limitation down to protect the parties involved in the fraud. Ms. Israel requests the court to review the websites as supporting evidence. The defected title for missing acknowledgments and certificates under Ohio laws cures a defected title after 4 years for minor issues. Ms. Israel's claim is mortgage fraud as stated in her answer on August 22, 2024. A defective title cannot cure itself after 4 years if there is convincing evidence of fraud. For this reason, Attorney Gurchik rejects the websites as evidence, as they show a disabled person, under duress by a community for years. If this was a minor certificate title defect, opposed to major repairs and inflated appraisal, UWM would have waited the 4 years to file foreclosure to cure the title. In addition, the websites show a housing scam at various stages and all parties associated who helped set the scam in motion and those in authority who failed to enforce the laws. 8. Cross Appellee's brief assignment of errors. Attorney Gurchik made a blanket statement that new evidence was introduced and failed to point out one single new evidence to support her claim. Stating the rule without showing any new evidence is irrelevant, a copy of the brief, redacted of new evidence would have sufficed. There was new evidence. 9. Reply. The missing certificate of acknowledgement and city approval documents would have been cured as of February 14, 2024, however this is a mortgage fraud case. The concealed POSI contained major repairs that Ms. Israel was not aware of and the appraised property value was grossly inflated. 18 U.S.C. 1014 pertaining to this case, in a nutshell prohibits overvaluing property to secure a federal home loan penalties up to $1 million and or up to 30 years in prison. Appraisal was $260,000 when in reality it was closer to $125,000. The loan servicers UWM and CMS collectively and with intent to defraud Ms. Israel, withheld the foreclosure to cure the defect title under Ohio Revised Code 5301.07, for the missing acknowledgments and city approval. However, this presumption of validity can be rebutted by clear and convincing evidence of fraud, undue influence, duress, incompetency or incapacity. Ohio Revised Code 5301.07, 2, b. 1. Parties with these issues can challenge the instrument within 4 years or any time afterwards. Courts require that the foreclosure process including the transfer of ownership or assignment of mortgage be properly documented and legally valid. For this reason, is why Attorney Gurchik failed to notify Ms. Israel at her last known address in Livingston, Texas, because she knew Ms. Israel would make claims of mortgage fraud as she has since after February 25, 2020. The trial court ignored the mortgage fraud claim. Concealing the acknowledgement form opened the door to allow the mortgage fraud that have a 10-year statute of limitations. January 08, 2030 the statute of limitations expires to make a claim for mortgage fraud. Unfortunately, Ms. Israel cannot file a mortgage fraud claim. Only the Federal Bureau of Investigation, FBI, or discovery during a foreclosure proceedings or others in authority can file mortgage fraud. Ms. Israel has been chased around the country, with death threats and on several occasions attempted murder, not due to a missing document, rather due to mortgage fraud claims that if convicted the sellers would possibly serve prison time. Ms. Israel raised judicial misconduct because she believes that the trial courts and 5 attorneys' actions impacted the fairness and outcome of the foreclosure. Instead of dismissing case #CV24-999054, the court officers decided they would go a different route to obtain the property via default judgment opposed to mortgage fraud. CMS has been in possession of this unenforceable mortgage for 2 years and 3 months, committing alleged blatant frauds and RESPA violations to protect Mr. and Mrs. Johnson and violate Ms. Israel. Because the Johnsons are a Caucasian couple in the real estate industry, have access to legal defense, and Ms. Israel, a single, Hebrew, woman of color, does not, is what it really boils down to place blame upon the party without legal counsel to protect and conceal crimes. This case should have never been filed in Cuyahoga County Common Pleas against Ms. Israel for a foreclosure, rather in federal court for mortgage fraud against all parties that participated in the transfer that defrauded the VA home loan and Ms. Israel. The title defect cannot be cured due to the missing documents that were concealed. The inspectors falsified the property condition and the appraiser inflated the value on a dilapidated property for Ms. Israel to obtain a VA home loan equates to mortgage fraud. On February 14, 2020, Ms. Israel walked into the property with major repairs, electrical and plumbing that the VA requires to be working before approval. On www.2591leroad.com, the inspection report by Detailed Home Inspection, Ms. Israel shows major repairs were concealed. Conclusion. This right here is a mortgage fraud case. Over the years, those in authority have supported the sellers, opposed to the buyer, because the sellers are Caucasian and apparently major players in Cuyahoga County real estate market. Despite the mountain of evidence on the websites that shows a clear case of a fraudulent house flipping that equates to mortgage fraud. Therefore, this court or no other courts should grant a default judgment or cure the title defect for missing documents, due to overwhelming evidence of fraud with the parties involved in the transfer and loan servicers' intentional delays. The loan documents Ms. Israel executed on February 13, 2020 are void of intio, because of the collective deceptive, fraudulent acts from the sellers, realtors, house flipper, title company, loan officers, underwriters, home inspectors, pest inspector, appraiser, City of Cleveland Heights POSI Department, City Council members, the Mayor, City Prosecutor, Board of Realtors, Cuyahoga County Property Tax Department, VA Home Loan Department, agencies that denied or failed to respond to complaints filed by Ms. Israel, neighbors who engaged in 24/7 hate crimes and death threats, loan servicers, who ran the statute of limitations down, 5 attorneys, who knowingly filed foreclosure opposed to mortgage fraud, the magistrate and judge who ignored mortgage fraud and ruled in favor of a default judgment. All knew the sellers committed mortgage fraud and all agreed to dump this $250,000 debt on a single, Hebrew woman of color, disabled war veteran, international press journalist, and coddle the alleged crime of the sellers. Princess Ada Israel has been accused of a debt and persecuted wrongfully to protect the sellers who are in the real estate industry. Princess Ada Israel is the living woman, proper person, not the corporate entity, here to settle and close this matter. The alleged debt of $225,313 plus interest rate 3.125% per annum from September 2021, granted from Cuyahoga Common Pleas Court, by Magistrate Amy R. Jackson and Judge Cassandra Collier Williams. Their combined decisions arose from a default judgment hearing, exclusively with the plaintiff's legal counsel on December 12, 2024, decided on December 18, 2024 and ordered for sale on July 3, 2025, that was filed on June 17, 2024 by Logs Legal Group, LLC, Tamara E. Gurchik, 009-0798, Christopher G. Phillips, 007-4249, Matthew Midland, 008-8290, Edward John Delp 4, 008-8641, Brian Tekulve, 102,063, on behalf of their client Carrington Mortgage Services, LLC, who allegedly conspired with the sellers, JJ Real Estate Solutions, LLC owners Jenna and Jeremiah Johnson, realtor and house flipper, who allegedly masterminded, orchestrated a network of professionals in the real estate industry, a community of hate-mongers, and those in authority, to execute a housing scheme that defrauded Ms. Israel of her retirement home on January 08, 2020. There is clear and convincing evidence of fraud, undue influence, and duress, under Ohio Revised Code 5301.07, 2, b. 1. The statute of limitation for mortgage fraud has not expired and the sellers remain in plain view operating day-to-day, property flipping, in the state of Ohio. For the record, this is not a simple foreclosure proceedings, this is tyranny, to gang up on a single person because they were defrauded. No law firm would assign 5 seasoned attorneys against a pro se litigant for one dilapidated single-family home with less than $250,000 debt. Make that make sense? Lines 1-20 * end of page 13. 11. Prayer for relief. An appeal has been filed. Ms. Israel respectfully requests that the 8th Appellate Court render a fair decision based on the evidence and alleged misconduct of the 7 officers of the court presented in the trial court, the appellant's brief and appellant's reply. After careful review, Ms. Israel requests that this case be dismissed with prejudice due to questions of fraud, deceptive business practices, violations of RESPA, intentional delays, and alleged judicial misconduct of the 7 officers of the court and any other just disciplinary actions. What say you, Court of Appeals, 8th Judicial for Cuyahoga County, Ohio, what say you? Respectfully submitted. Underscore 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 underscore. Princess Ada Israel, Pro SE. 4364 Western Center Boulevard, Suite 5077, Fort Worth, Texas 76137. 303-552-3777. 2591 Lee Road @gmail.com. 12. Certificate of Service. A copy of the foregoing brief was sent pursuant to App.R13 by United States Postal Service's regular mail on November 26, 2025 to Tamara E. Gurchik, 4805 Montgomery Road, Suite 320 Norwood, Ohio 45212. Underscore 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 on. Princess Ada Israel, Pro SE. 4364 Western Center Boulevard, Suite 5077, Fort Worth, Texas 76137. 303-552-3777. 2591 Lee Road @gmail.com. 13. Appendix. Affidavit publication August 19, 2024, 17-20. Answer to complaint August 22, 2024, 21-25. Email March 20-21, 2023. Agreed to expedite foreclosure, 2630. Page 4 Defendant Appellant's Brief Correction, 31. Page 28 Defendant Appellant's Brief Correction, 32. Page 29 Defendant Appellant's Brief Correction, 33. Page 30 Defendant Appellant's Brief Correction, 34. Signature page of complaint June 17, 2024, 35. VA moratorium November 30, 2023, 3637. VA notifies loan servicers November 17, 2023, 38-43. 14 websites. www.2591leeroad.com, www.2591leeroad.org, www.allnochualnerwelcome.com, www.allnochualnerwelcome.org, www.posohio.org, www.pointofsaleinspection.org, www.pointofsaleinspection.com, www.robinhood666.com, www.wegothetrodhandapproved.com, www.
And this is the copy that was filed in court there, and I'm just going to scan through it. And show the exhibits.